former governor of Maharashtra, Bhagat Singh Koshyari. The court is currently hearing the case between Eknath Shinde and Uddhav Thackeray over the Shiv-Sena split. Now remember, Mr. Koshyari had ordered the floor test, which led to the ouster of Uddhav Thackeray's government last year. While hearing the case, the Chief Justice of India posed some serious questions about the role of the governor. He also questioned, in fact, they also questioned the rationale behind the former governor's actions. Let me quote the relevant parts of the Supreme Court observations. And I'm stressing here, these are only observations. The court said, "We are of the view that governors should not enter into a political arena. Here is a case where the governor precipitated the fall of a government. Was there a constitutional crisis to call for a trust vote? Governors cannot be a willing ally in bringing down a government. This is a sad spectacle in a democracy." This is what the Supreme Court observed. When the Solicitor General argued back that there was a threat to the lives of some MLAs from the Shinde camp and that the governor could not have been a mute spectator, the court posed another question. They asked, can the floor test be called only because some MLAs have reported a threat? The Supreme Court asked, did the governor act in anticipation? The Chief Justice said that the government of the MVA, that's the Maha Vikas Aghadi, had two other partners, the NCP and the Congress, a strong bloc of 97. Did the governor expect that the Sena will break and one of the factions will join hands with the BJP? Now, it's important to note that these are observations. They may or may not reflect in the final verdict of the Supreme Court. That's important to remember. Either way, one thing is clear. This case will have long-term implications on the role of governors during political crisis. It could also set a precedent for floor tests and party splits. Let's quickly get in a perspective from two lawyers who are joining us on the broadcast. Thank you both very much for being with us. Aditya Pratap and Namit Saxena, always good to have you on the show. Who should I start with? Maybe I should start with Aditya Pratap. Aditya Pratap, what do you make of the Supreme Court's observations today as far as the Maharashtra floor test is concerned? What is the Supreme Court trying to say here? These are observations, but what is the Supreme Court trying to say here?
Well, I think the Supreme Court is essentially trying to comply with the constitutional mandate. Indeed, India does not have a presidential form of government, and our governors are not the powers that be. They have to act on a governor has to act on the aid and advice of the Council of Ministers. And first and foremost, the Supreme Court has rightly pointed out pertinent questions, because remember, things like a floor test, etc., they are to be called in exceptional circumstances and not in, at the arbitrary whims and fancies. For example, let's suppose there was one conversation in which, there was a hearing discussion wherein the issue of threat to life was concerned. The point is, just because there's one threat to MLA's life does not mean that you call a full-fledged floor test. Rather, to the contrary, there is a, in the Constitution, there is a mandate. You have a thing called national emergency. You have a thing called constitutional emergency and others. Like when the governance or government of a state cannot be carried on in accordance with the law of the land, the governor has to give a recommendation to the president. So, in short, it's a very stringent procedure which is not invoked. So, what the Supreme Court is essentially trying to query the Advocate General, and it posed some hard-hitting questions, that the governor has clearly transgressed his mandate imposed under the Constitution of India. In fact, we must note that the powers of a governor under the Constitution are even narrower than those of the president. And every action of the governor has to be on the basis of the aid and advice of the Council of Ministers. And agreed, ultimately, it is a rule of the land. That one issue which will also come up here is that ultimately the government should enjoy the confidence on the floor of the House. So the governor, in the event of any doubt, he would have to convene a floor test in order to determine. And of course, this is a case where Uddhav Thackeray himself resigned before the floor test ever conducted. So yes,
correct.
Probably
but
what the Supreme Court
the fact also is, but what the fact also is, Aditya and Namit, that 34 of the MLAs of the Maha Vikas Aghadi who belong to the Shinde faction had written to the governor. And there was the opposition letter in any case saying that this government has lost the trust of its people and therefore you should call a floor test. So why is the Supreme Court saying or observing that did the governor act in anticipation. If 34 MLAs are leaving the Mahavikas Aghadi, yes, you can argue that there was dissent only within one party in that coalition, that the Congress was a strong bloc, the NCP was a strong bloc. But the fact is, if 34 MLAs are walking out, it means your government doesn't have the numbers. So, Namit, is it fair for the Supreme Court to say that that the governor probably acted in anticipation? Another thing that they are saying, before I let you answer, is this. This is the Chief Justice of India saying, the governor has to ask himself this question: what were you fellas doing for 3 years? If it was a month after the election takes place and they suddenly bypass the BJP and join the Indian National Congress, that's different. 3 years, you cohabit, and suddenly one fine day, a group of 34 says there is discontent, enjoying the spoils of office, and suddenly one day you just decide you want to end this happy marriage. So I just want to ask you, in hindsight, we know that the Mahavikas Aghadi government didn't have the numbers. So what is the harm if the governor ordered the floor test?
There is no harm. In fact, the governor is right in ordering the floor test. I'll tell you why. See, we are a multi-party democracy. In this case, particularly, what has happened is there was a pre-poll alliance and a post-poll alliance. Now, when the Chief Justice of India observes and says that this was a happy marriage for 3 years and suddenly it became an unhappy marriage, no, sorry. The discontentment was throughout. Because there were ideological differences, etc. The Supreme Court can't assume and say that they were in a happy post-poll alliance for 3 years and suddenly they are saying that no, there's an unhappy marriage. You want to be married to somebody else. No, sorry, this is wrong is one. Second, जब आदित्य जी बोलते हैं तो बड़ा मजा आता है, जब सही कभी कभार बोलते हैं तो और मजा आता है. He's right in saying that the governor was very well within his rights to order for a floor test, and a floor test is the answer to such a problem. Now, the Supreme Court today, observed that that the governor that has to ask himself. Of course the governor has to ask himself. The very nomenclature governor, he has to govern the state. He can't be a mute spectator and can't be immune to ground realities. We have 40 people are saying that we have a threat to our lives. There are 40 citizens of the country, elected legislators, are saying that we have a threat to our lives, and the governor will just sit and then only when something happens, then only I'll do something. Till then I'll just sit and wait and not anticipate and not do anything at all. Are we supposed to have a governor like this? No, sorry. So the Supreme Court is not right factually in saying that, that there was no occasion for the governor to call for a floor test. Rather, I would say the governor was right and the governor is duty bound. And the governor would have failed in his duty if he would have not called for a floor test. In this case, what has happened is Uddhav Thackeray resigned before the floor test happened. Otherwise, if the floor test would have happened, these proceedings would have flopped completely out of question. So, the fair or not, but I think factually the Supreme Court has to revise, their observations today. And as you rightly said, these are just observations. The final judgment may be, after hearing all the sides.
Aditya, would you want to respond to that?
Well, see, first and foremost, we have to understand that, okay, I will go by, see, India follows the Westminster model of democracy, wherein the government has to enjoy the confidence of the House. Now, if I have to view this case from an impartial perspective, first and foremost is that as the Supreme Court continues its hearing in the matter, several questions will arise. One might arise, like one party is claiming of party democracy. That is that, can the party be governed by one man? But then the issue will arise that what if the MLAs do not obey the party whip? Third thing is that the Sena MLAs can always say that, because a governor, like, I'm not going to go into the merits or demerits before Supreme Court, because then the MLAs can say that there was a pre-poll alliance, we crossed sides and violation of the party ideology and other things. But the most important thing is the governor cannot say that there's a threat to MLAs' lives and directly take some extra constitutional steps, because there's a threat to, unless until there's a grave danger to the governance of the state. You cannot take any steps which go against the advice which is tendered to you by the Council of Ministers. Now, of course, we have Article 175 of the Constitution of India. We are not doubting that. But the Supreme Court in the present case is going to the question whether the government acted in haste. If we look at the functioning of Bhagat Singh Koshyari, yes, questions can arise that you did not follow perhaps the strict mandate or adhere to the strict limitations of governor's power under the Constitution of India. So the question will arise, did he tilt a bit?
Let me...
Of course, ultimately, we are not disputing party democracy. We have the Election Commission order, which also says that
No, the
because
fact
party is
is,
not governed by one person.
the fact is, anyone who knows Bhagat Singh Koshyari's background will say he is a political man, right? He's an RSS veteran. He's been vice president of the BJP. He's been chief minister of Uttarakhand, etc., etc. Rajya Sabha MP, BJP Lok Sabha MP as well. So, is he a BJP man? Of course, he's a BJP man. But just expanding on that argument, my last question to Namit. Namit, the Supreme Court also says, and I'm quoting them, just being a little careful here. Was there any constitutional crisis to call for a trust vote? A governor cannot be a willing ally in bringing down a government. This is a sad spectacle in democracy. Was there a constitutional crisis, Namit Saxena, in Maharashtra? No, there wasn't.
Yes,
There was no constitutional
this
crisis.
is the exact constitutional crisis where elected legislators are going to the governor, giving a letter saying that please organize a floor test is one. Second, we have a direct threat to our lives. What more can be a constitutional crisis where the elected legislators themselves are saying that please save us? Is the governor, going to just sit back and say, no, let anything happen to you? Yeah, the governor, by the very nomenclature, is supposed to govern. The governor can't just sit back and say that I won't do anything. And Mr. Aditya Pratap used the expression extra constitutional. This is exactly what the Constitution says, that you have to organize a floor test. The governor would have flopped in its duty to not organize a floor test in this case. The governor is, and see, the Supreme Court can't step into the shoes of governor. This is the governor's discretion. The discretion exercised either way. Cannot be questioned like this unless it was beyond legislative competence or exercised in an arbitrary manner. So here is the governor who is, leave apart whatever political background he may have had, political backgrounds you have seen of judges, etc. also, who have, hold constitutional posts. Is every governor bound to be questioned only because of the political background? No. It can't happen like this. Otherwise, all governors throughout, because this is, one of the basic criteria.
But Namit,
which you choose
governors
when you appoint
increasingly in this country.
Experience.
But Namit, you and I both know that governors increasingly in this country are behaving not like governors, but like politicians. In Kerala, in Tamil Nadu, in Andhra.
See, that is not something which, which we can say, because there are many factors which are to be considered in these cases. It can't be that governors have become politicians now. We can't just make a general statement like this. We have to be very careful of the statements we make on national media. See, we can't say that governors have become politicians. By very virtue of their appointments, we can say their appointments, political background is a tool to solve the queries of appointments of governors. With their background to govern a particular state, they have to know the law, they have to have the reality check they have. But once they become, or they accept the offer to become a governor, they should very well shed off whatever political color they have, because the governor's office, in my opinion, cannot have a
but
political
that doesn't
color at all,
happen.
and it should not have.
No, that is an ideal situation.
It requires judicial review.
Namit, that is an ideal situation. But Aditya, we know that is not how things have played out in India in the last 1 year, one and a half years.
Lawyers are also dreamers. We can dream of ideal situations.
I would like to bring attention to Article 163 of the Constitution of India, which pertains to the governor's discretion. That when the governor acts in discharge of the executive power, he shall act under the instructions on the advice of the Council of Ministers. But then there are some constitutional functions which require him to act in his discretion, and whether the function is within the executive domain or within the governor's discretion, that also has been left to the governor's discretion. So on this point, I feel that the Constitution, when the founding fathers framed the Constitution, they had envisioned certain limits on the powers of the governor. But now we are in an era wherein the central government appears to have obtained such a powerful mandate that it can sort of it appears to be pushing the limits and boundaries of the constitutional system, which is why we see that, where there's a loophole in the law, it is being used. Like, for instance, today, if the MLAs went away, the speaker had the powers to invoke the Anti-Defection Act. Now, of course, ultimately, every matter would end up going before the Supreme Court. And here, then another issue of party democracy will come. So, yes, I'm not saying that there's a watertight case involved here. But yes, I do respect the approach of the Honorable Supreme Court, that probably the Supreme Court is trying to pass a recent judgment, taking into account the current scenarios and the new challenges which have emerged through the constitutional fabric of the country. Because, it's like, as Hitler said, the best way to destroy democracy is using the weapons of democracy itself. So the Supreme Court might be trying to incorporate additional legal safeguards into the role of the governor and vis-a-vis party democracy. Because come what may, no matter how right you are, party cannot be subject to the will, the whim of a family or the others. So yes, it would be interesting to see how the proceedings of Supreme Court pan out.
Absolutely. That's exactly what I was about to say. These are just observations. They may or may not reflect in the final order. And the final order, when it comes out, will be very interesting. Will have larger implications as well. Aditya, we'll leave it there. Good to have you on the show. Namit, always good to have you on the show as well. Thank you very much. I'm slipping into a quick break on the show here. There's more on